Good morning, everyone. Thank you for joining. My name is Niquelle Allen. I am the Director of Open Government with the DC Board of Ethics and Government Accountability's Office of Open Government. Thank you so much for being here today. This is almost the end of our FOIA training series. I also want to apologize that we had to move the date and time of this presentation. We had our Vega board meeting yesterday and had some issues going on in the building. So I wanted to bring my best self to you all today and given this presentation. So we thought it best to move it to today. I also realized that I am standing in between you and your vacation or weekend plans. So I will try to move through this presentation as expeditiously as possible. If you have questions throughout, since it's not a lot of us here, please feel free to unmute yourself, come off camera, and just stop me and ask a question. You can also put any questions you have in the chat. I've got several of my colleagues here from the Office of Open Government who can help me in answering those questions. If you put them in the chat, I can't necessarily see them with my view, but if something needs my attention, the Office of Open Government staff will let me know. So let's get into it. This is electronic records, text messaging, and artificial intelligence, modern FOIA challenges, training for FOIA officers and other agency officials. If you're not a FOIA officer, we're glad you're here. But what we're doing here is introducing that government records are no longer confined to paper files and email inboxes. Modern communications and AI tools are reshaping public records obligations. I've been a district FOIA officer in FOIA since 2002, and I was recalling this morning as to when I started my career with what is now the Alcohol, Beverage, and Cannabis Administration. It was in APRA. I was the FOIA officer, and I remember having to go to our archive records person and get paper records from her, go to a printer, copy them, assemble them, put them in an envelope, and mail them out. So we are far, far away from that. We are now in the digital age, and as a government, as you all know, most of our business is done electronically, and that is even evolving as technology evolves. So we hope this presentation today will give you some tools around those issues. I'm going to go off camera because I've got a bunch of documents here, and I don't want to distract you all with me moving, but I am here. So please bear with me with that. All right. So our agenda today, first we're going to start with defining electronic records. Then we're going to move on to text message and personal devices. Next is messaging platforms and retention. We're going to talk about AI generated records, AI risk, and AI litigation. This presentation is practical, legal, and operational. So we're going to go through these ideas and concepts. I have one question embedded in here that I'm going to ask you all to help me by participating in. But other than that, just sit back and we'll enjoy this discussion. So why this matters. This is both a legal and operational challenge for us in government. Agency practices are evolving faster than public records laws. This is why it matters. Mobile first communications. A lot of you today are on mobile devices or on laptops or sometimes different devices. And this is shaping how we create records. We are also in hybrid work environments. Like right now, this is on Teams. I'm not standing in front of you in a room and we're having this discussion. It is on electronic format. So there's a question even with this presentation about records. What type of records are we creating? And are these subject to FOIA? AI assisted workflows. Now, this is new. We all have now access to Copilot and other technologies for AI to use in government service. So what type of records are we producing there? That's the question. And we all know we're in an environment where the public trust that the government is gone down. So new technologies are also shaping their expectations about the type of records that they can receive. And there's also a litigation and reputational risk with using these new technologies that we need to always be mindful of. So I'm going to start with the basics. So what counts as a record? We go over this in most of our FOIA trainings, but I think it is good for me to talk about it this morning in this context, just as a reminder, because although the technology is changing, our laws do not change that fast. So what is a record? The DC Code definition of a record is found in Title III of the District of Columbia Administrative Procedure Act. It incorporates, DC FOIA incorporates certain global definitions from the Administrative Procedure Act, including the definition of a public record. So for the purposes of FOIA, the term public records includes all documentary materials regardless of physical form or characteristics, prepared, owned, used in the possession of, or retained by a public body. Public records include information stored in an electronic format. So that last section is key with new technologies emerging. So the District of Columbia has looked at electronic format as encompassing a lot of the new technologies. So that's where you will see FOIA capturing a lot of the things that we discussed today. So agencies need to make sure that you are stressing to your employees that you cannot avoid FOIA obligations by changing communication platforms. That's important. I know a lot of us communicate through Teams chats. We communicate through text messages and other formats that are non-traditional. They're not government email, but our colleagues and others who we serve need to understand that it could be creating records subject to FOIA with those communications. And content matters more than format. We will be on that theme throughout this presentation. So potential electronic records could include emails. That's our traditional one. Text messages, Teams chats, Slack messages, shared documents. So we're sharing documents in the cloud. This morning, I shared this presentation with my colleague in the cloud. So that's another source of electronic records. Calendar entries. What are you putting in your calendar? What calendar notices are you sending out? AI generated drafts. If you attended my training and ethics week, I talked about how you can use the AI tools that we have to help you get started. So are those AI generated conversations and draft subject to FOIA? Are they electronic records and metadata? Although the technology is changing. DC FOIA applies to records regardless of technological medium. So under FOIA, there's a broad presumption of disclosure. So that means as a government, we've chosen to be open rather than closed, to reveal what we are doing through our documents and records. We're also looking at our statute, which has technology neutral definitions. That is purposeful to make sure that as technology evolves, our law still makes sure that we have the same obligations to the public of transparency. Retention obligations. We all have record retention schedules and obligations to keep government records so that those who come after us can understand what we have done. Agency control and possession. That is a key concept because we need to look at what the agency actually keeps in its repositories, in its devices, computers, warehouses, etc. So as I've discussed, high volume creates compliance pressure. So we have had an electronic records explosion since I started government in 2002. All of our communications are made through some type of computer or device. Modern government agencies generate thousands of emails daily that could be subject to FOIA. We are on Teams a lot. Some of those chats can be subject to FOIA. Text-based workflows, shared cloud documents, and AI-assisted outputs. So transparency expectations lead to government trust. So this is the perceived new technology problem. So new and emerging technologies have become a routine method of conducting government business. Government employees are no longer communicating only through memoranda, letters, and official emails. They're also using SMS messages, multimedia messages, WhatsApp, Signal, Facebook Messenger, Microsoft Teams, and other third-party applications. If government business is moved from an official email system to a personal cell phone or a new application, does the public's right of access depend on the technology selected by the government employee? I think there's a wood there. We need to change that. Sorry about that typo. The answer is no. Public access does not turn on whether a DC government employee chooses to communicate via email, text messages, or third-party application. Public access turns on the content. Is this reflecting the government doing the government business? If so, that communication, that use of technology could be a record that is subject to the Freedom of Information Act. So I wanted to transition into a high-risk area of modern FOIA compliance, and that is text messages and personal devices. As I just stated, if government business is discussed, the platform may not matter. So courts are increasingly focusing on the substance rather than device ownership. So are text messages public records? Generally, yes. The key question is, was the message created or retained in connection with public business? So you could be using this on your phone, iMessage, WhatsApp, Signal, also the group chats. So there is case law supporting that text messages are public records. So under federal FOIA, a record can exist in any format, including electronic format. That is the same as the DC law. In the case, Citizens for Responsibility and Ethics in Washington versus the Department of Justice, the federal court treated a text message conversation as a record and emphasized the importance of preserving the context and the conversation rather than viewing each individual message in isolation. And that case was in 2020 in DC. In Detroit, a Flag versus City of Detroit, a federal court in Michigan applied Michigan law and concluded that text messages exchanged by city officials in the performance of official functions could be public records. In Neeson versus Pierce County in Washington State, the Washington State Supreme Court held that work-related text messages could be public records even when they were stored on a personal cell phone of a public employee. In Vermont, the same conclusion was reached in Towsing versus the Attorney General of Vermont. The Vermont Supreme Court concluded that public records stored in private accounts remain subject to the state's public records laws. So again, although these authorities are not binding on DC FOIA, they reinforce the same principle. Government officials cannot place the public's business beyond public access by merely moving it to an electronic device, including private equipment and private accounts. So, a lot of agencies in the district have bring your own device policies. Mine, for example, we do not have that. We provide our employees with a government cell phone that makes things easier when it comes to record retention and FOIA. But a lot of agencies do have BYOD, and there is a risk with that. There are some legal concerns, agency custody and control of that device, what happens when the employee leaves the government, and there's a FOIA request. What do you do once the agency no longer has that person in their office, does not have that device in their office? And what are the preservation obligations when using your own device? They should be the same, but they again need to be communicated to the employee. If there's litigation, there are discovery risks. Again, what happens if the employee is no longer with the district? How does the district get that information? And employee privacy conflicts. Again, that is an issue that can come up, is that this is my private phone. There may be information on it that I am not willing to reveal. I don't want to give a FOIA officer or a government employee my personal phone for any reason. Also, the same risk occur in convenience tools. These are record management risks. So we're looking at use of Signal, Slack, and team chats. A lot of these have auto delete functions. Records device management for size of what's kept on the device may auto delete certain information. That creates a conflict with governmental obligations. An informal communication culture. We may have colleagues in our agencies who are inadvertently creating government records through casual conversation. Ephemeral text messaging is also a risk. This office has opined on that issue, saying that this should not be used at all. For those who don't know what ephemeral messaging is, that is when, similar to us having a phone conversation, the messages disappear as soon as the communication occurs. So that's not retained at all on that device that you're using for that ephemeral messaging. That is in WhatsApp, for example. Fragmented retention systems. So these applications rely on the user, in most cases, not our centralized agency, Octo, to retain those records that they're creating on those devices using those tools. So auto deletion is a major risk. They conflict with record retention laws, litigation holds, and what that is when there is a case against the district and you hear from your general counsel or the attorney general that you need to preserve all records related to a certain matter. If you're using these disappearing messages, you can't do that. FOIA preservation duties. Again, if you are using WhatsApp or other type of ephemeral systems to communicate, you are not preserving records as a government employee as you're required to. So, summary, messages, what is and what is not a public record? So, a text discussing agency decision, program contract, investigation, meeting, personnel action, or other official matter, I think is clearly a public record under DC FOIA. Government business text on a personal phone, that is also a public record under FOIA. Government business on WhatsApp, Signal, Teams, or direct message, I would say that's a potential public record because there's not a lot of jurisprudence on that particular issue, but we have issued an opinion stating that those are public records. So we recommend that you treat them as such in your agency. Purely personal conversation, unrelated to district business on a personal device, that is not a government public record. Personal content stored on a government device, well, it might be in government custody, but it's probably non-responsive or protected by some privacy exemption. So FOIA would likely not treat that as a government record, even though it's on a government device. Government business text containing exempt information. It's a public record, but exempt portions may be redacted or withheld. So I'm going to give you a hypothetical. Please come onto the audio and respond or put it in the chat. And my colleagues, please let me know what people are saying in the chat. So let's look at a hypothetical that you all might be faced with as FOIA officers and government employees. So when do text messages become records? A senior official coordinates policy decisions through text messages on her personal phone. She has deleted some of the messages. What should the FOIA officer do when the agency received a request for those messages? Any responses? Anyone have any ideas what the FOIA officer should do?
No one has responded yet, but I'm sure they're working on it.
Are we silent because it's a Friday? Okay, I'll keep
Yeah,
this
I didn't
open
see
for,
nothing in the chat, Niquelle.
okay. I'll keep this open for a few more seconds just to see if there are any responses or any thoughts. All right. Put a hold on what message
Yeah.
remains. Thank you, Valerie. That's a good one. So we've got one. So we'll move on unless there's anyone who wants to come and say anything about it. All right. So if a DC employee or official texts about district business, the message is potentially subject to DC FOIA, even when sent from a personal phone. The agency must search for the record, review the record, release the non-exempt material, and justify any redactions or withholding.
There were,
Okay, I
I'm
do
sorry,
see
Niquelle.
responses.
Yeah.
Okay. So, all right, I see a question. One idea, this is from Katrina from DMV. Thank you. One idea is to request that the person not delete any additional messages. Another is to, if necessary, request messages from the cell provider. And that's a great one. And I'm glad that you mentioned that. We can, through Octo, uh, also do that. We could issue subpoenas and things of that nature, depending on the seriousness of the matter. But what we need to do as an agency is to first see if the employee will provide that device and segregate the messages that remain. And then you're going to have to respond accordingly to the FOIA request that no records were found. So help to answer when text messages become records. So the governing rule, whether information is a government record, is content-based, not device-based. A text about district business can be a public record, even on a personal phone, while a purely personal text is not made public merely because a government employee sent it. Government officials should be advised of their record retention obligation when conducting government business via text messages on government phones and private devices. So the agency should ordinarily not seize or indiscriminately search an employee's entire personal phone. When there is reason to believe responsive government business text on a personal phone exists, The FOIA officer should direct the employee to conduct a good faith search using relevant names, dates, and search terms, and provide responsive government records to the agency. So the recommendation here is to put the onus on the government employee to do the right thing and provide those records instead of you taking custody of that device and doing it yourself. The statutory obligation for the FOIA officer is to conduct a reasonable electronic search. The FOIA officer should provide a declaration or affirmation describing the search that meets this standard. We say this in all of our FOIA sessions, that that's a good practice to memorialize what you have done so that if this matter goes to litigation, there is evidence that the government conducted what is called a reasonable search. So the FOIA statute does not expressly list text messages. As I said earlier, it uses a technology neutral definition. So again, public records includes documentary materials, regardless of physical form or characteristics prepared, owned, used in possession, or retained by a public body. The statute expressly adds public records include information stored in an electric format. So this is how the district captures text messages. As I mentioned earlier, in 2022, OOG issued an advisory opinion on how DC FOIA law applies to text messages. We said in the opinion, which is linked below, that a text created, received, or used by a district official or employee within the scope of government employment is a public record. The result does not change because the message is stored on a personally owned phone. Government personnel cannot avoid FOIA by conducting business through personal devices or private messaging accounts. And DC Code 2-532A gives any person the right to inspect or copy public records subject to statutory exemptions, and also requires public bodies to make reasonable efforts to search for records in electronic form. So that means text messages. In our opinion, set that forth in great detail. So practical guidance for you as a FOIA officer. So when a FOIA request may encompass text messages, the FOIA officer should begin by identifying the custodians of the record. You should ask whether those individuals in your office use district-issued cell phones, personal cell phones, Microsoft Teams or other internal messaging platforms, third-party applications, personal emails, or personal or government cloud accounts, or any application with the automatic deletion feature. The FOIA officer should coordinate with the agency's Office of General Counsel, the agency's Record Management Officer, and information technology personnel. That's usually your IT lead or the Office of the Chief Technology Officer. Search instructions should be documented. So that, again, protecting yourself in the agency, make sure it's somewhere memorialized what you directed the DC employee or official to do. Employees should be told not to delete potentially responsive messages, and the agency should maintain records of who searched, what was searched, what search terms were used, and what results were produced. The agency should preserve enough of the conversation to provide context. After the collection, the FOIA officer should determine responsiveness, apply any and all lawful FOIA exemptions, redact protected information, and release all reasonably segregable non-exempt portions of the record. Most importantly, the agency should not assume that a search for official email accounts constitutes a complete search when there's reason to believe government business was conducted through text messages or other electronic means. So I would like to pivot and talk about record retention. A lot of you are the record retention officer for your agency, or you work with that person in your FOIA responsibilities. The Public Record Management Act independently provides that records documenting public business are public records regardless of the medium. And that's in DC Official Code Section 2-1701-13. It also provides that records created or received in the course of official business are district property and cannot be destroyed except as authorized by law or an approved retention schedule. So DC FOIA and the Public Record Management Act perform different but related functions. DC FOIA governs public access to existing records, and the Record Management Act governs how government records must be maintained, preserved, and lawfully disposed of. So as a FOIA officer, you should be aware of the Records Management Act's requirements and rules and your agency's record retention schedule. DC FOIA does not require every government record to be retained permanently. The applicable record retention schedule determines how long a particular category of record must be kept. However, records cannot be destroyed merely because they later become the subject of a FOIA request. Destruction must be authorized by an applicable retention schedule or other lawful records disposition authority. Once an agency receives a FOIA request or reasonably anticipates litigation, an investigation, an audit, or other preservation obligation, it must ensure that potentially responsive records are not destroyed while that matter remains pending. So, in the context of new technologies, we are required to maintain those technologies to respond to FOIA requests and also within our record retention responsibilities. So for record retention, here are the questions agencies should answer. What platforms are approved? Who preserves the records? Is it an individual in your office? Is it everyone in your office? How are chats archived? Is that the responsibility of the individual employee, or are we doing this on a collective or enterprise basis? What happens after employees depart? Do you have a procedure to obtain records that they may have created on personal devices or through other applications? The Record Management Act, which I stated before, provides that records documenting public business are public records, and records created in the course of official business are district property. So in 2024, the retention schedule of the District of Columbia was revised to reflect the use of new technologies. The district has said in General Record Schedule 20 that electronic correspondence, including email and text messages, chat messages, Microsoft Teams messages, and attachments that qualify as district records are covered. The schedule provides for the permanent retention of qualifying electronic correspondence of senior district officials, 7-year retention for messages of most non-senior officials, staff, and contractors, 3-year retention for messages of designated support or administrative personnel, and shorter retention for properly classified transitory records. For senior officials, official business conducted through a personal or non-official messaging account must be copied or forwarded to an official electronic messaging account within 20 days. So keep this development in mind and make sure that you communicate it through your agency. This development reinforces our OOG's opinion's central principle that text messages are not separate or a lesser category of government records. They must be identified, managed, and preserved according to their content and the applicable retention schedule. So I have a link here to the Office of Secretary's website that has the Office of Public Records General Records Schedule 20. Please make sure that you are aware of that and your agency is aware of these requirements with respect to electronic records. So now I'm going to pivot into AI-generated records, AI risk, and AI litigation. I will say at the outset that this is a new and emerging area, and there is not a lot of established law that is specific to this medium. So what we're going to go over today is for your awareness. There is some guidance, but keep in mind the general principle when it comes to AI that we stated at the beginning of the presentation, that the law has not changed. Our obligations to the public regarding transparency remain the same regardless of the medium that we are using as a government. So AI is different. Here's the emerging landscape. These AI generated platforms, etc., could be government records or subject of a FOIA request. Those are AI prompts, AI generated reports, large language model outputs, risk score, predictive recommendations, training data sets, bias evaluations, validation testing, human review documentation, and model governance records. So AI is already transforming the government as we know it. It's no longer a future technology. It is increasingly being used by government agencies to improve efficiency, analyze information, automate routine tasks, and enhance public services. As AI becomes integrated into district government operations and to federal and other government operations, it creates new challenges for transparency, records management, public access under the Freedom of Information Act. Many agencies are already experimenting with AI, while others have implemented AI in limited operational areas. FOIA officers may not even realize AI is being used within their agency. As AI adoption expands, FOIA professionals must understand both the opportunities and legal implications associated with AI generation and information and AI-assisted decision-making. Every FOIA officer needs to understand AI because you're uniquely positioned at the intersection of transparency, records management, and technology. You don't need to be an expert or AI engineer, but you do need to understand enough about AI to ask the right questions, evaluate agency practices, and recognize potential legal and operational risk. So is anyone, and you please put this in the chat, aware of their agency using AI, or has anyone received a FOIA request for AI? Or AI-related materials? I know we have not received one. Okay, I see Valerie received one at the council. All right, we have not yet. Okay. So this is, again, this is new. So keep in mind that if you have not received one already, it may be coming. But it's interesting to see that we at the district have already received an AI request. So that says to me that if you haven't received one, it's coming. I see that colleagues are using AI to generate records, yes, at DOES. So be prepared. Thank you all for responding. So the principle here, the technology is new, the principles are not. So artificial intelligence changes how we create and management information. DC FOIA still ensures that the government remains accountable for that information. And these questions are rising as a result of the government's use of AI technologies. So let me get into, which is going to be the largest part of this discussion, the FOIA-related artificial intelligence litigation. So there are a few federal cases involving AI, but not yet that I've seen a specific DC-related case, but I assume it will be coming. Not to be ominous, but we need to figure out how to resolve these issues. Okay, so the first case is Democracy Forward versus the State Department and the U.S. Department of Housing and Urban Development. This is case number 125-CV-2020. It was filed on June 27th, 2025 in the District of Columbia. So Democracy Forward submitted FOIA requests seeking records about alleged federal use of generative AI to review international students' social media activity and assist with visa revocation decisions, evaluate federal employees for termination or political alignment, identify HUD regulations for repeal or revision, and communicate about DOGE-related AI projects. So from the plaintiff sought records due to the government's use of generative AI across the government, this federal government, to eliminate programs, surveil viewpoints of private individuals and federal employees, rewrite agency regulations, and cancel contracts. Request for use of AI in visa evaluation, performance reviews, and personnel recommendations. So the plaintiff sought prompts, chats, AI recommendations, emails, notes, and memo. The complaint alleges that the State Department and HUD failed to issue timely determinations and produce the responsive records. This case is particularly important because the requested records appear to include not just general AI policies, but potentially prompts, AI-generated recommendations, communications discussing model outputs, list of regulations identified by AI, instructions provided to government employees, and records showing how individuals relied on AI results. There is currently a joint status report that the parties filed on June 1st, indicating that the federal agencies have located AI-related records, but have withheld substantial portions of those records under privileges, including the deliberative process privilege and the presidential communication privileges. So the major unresolved question here is the AI prompt or model itself deliberative, or is it merely factual or analytical materials that officials considered? So we are going to monitor this case here at the Office of Open Government to see what happens with these records now as they're being released. Will the plaintiff challenge the exemptions or not? So I see a question. No, there's not a corresponding slide. It's still slide 32. I'm reading from my notes. But if you have more questions or need more information about any of these cases, I can certainly send them to you. Please send me an email and I can forward you more information. I didn't want to have a whole lot of slides and take up a lot of time, so I'm just using notes. All right. The next case is also from Democracy Forward. This is Democracy Forward versus OPM, GSA, HUD, and the Office of Management and Budget. This case is also open with active docket activity. And there is also a order from the judge that has the parties discussing the ongoing production. The parties are producing information in accordance with this lawsuit. This complaint alleges that the Trump-Vance administration is pushing a deregulation agenda using artificial intelligence. The plaintiff filed several FOIA requests for records regarding the AI court issue where the search is adequate. So this action sought records from OPM, GSA, and HUD and Office of Management and Budget concerning the use of AI in federal deregulation and in personnel activities. The request that they filed actually covered emails, messages, attachments, and communications with terms associated with AI and DOGE initiatives. So I will provide more information about these cases for you in the chat after the presentation and provide you the links to the Democracy Forward cases if anybody's interested in more information. The search limited to email. So this was a largely email search. They were looking for the words artificial intelligence. They were also looking for particular emails from some specific government employees and officials where they use terms like bot, agent, LLM, or automation. So again, this case illustrates the types of FOIA requests that you may receive regarding the government's use of artificial intelligence. So again, these are cases that are ongoing that we will continue to monitor here at the Office of Open Government. So the next case is ACLU versus NSA. And this file was filed in the Southern District of New York. The ACLU sought records on the National Security Agency's AI governance, civil liberties reviews, and bias assessments. The ACLU requested studies, roadmaps, reports, audits, and governance records concerning the NSA's deployment and of artificial intelligence. The request specifically sought information about privacy, civil liberties, bias, safeguards, and the NSA's use of AI in intelligence and surveillance activities. The ACLU filed this suit after NSA failed to produce the requested records. The ACLU continues to identify the matter as ongoing. So why this case matters? It's likely to test the application of several exemptions to AI records. So exemption 1, that's classified national security information. Exemption 3, information withheld under intelligence statutes. Exemption 5, deliberative attorney-client or work product material. Exemption 7, records compiled for law enforcement purposes. It may also raise important segregability questions. So even where the operational details of an intelligence models are classified, information such as bias testing, civil rights, model governance policies, human review procedures, and metrics might be able to be revealed as not falling under one of the exemptions. So this case directly addresses public access to government AI risk assessments and operational policies, but no major merits opinion has yet been created by this lawsuit. So this is a series of two, I would say, very significant cases. So I'm going to spend a little bit of time on it. This is Epic again versus the National Security Commission on Artificial Intelligence. This suit was filed in 2019, and this case is valuable because it puts an open government doctrine directly into the institutional design of federal AI policymaking. So you know that this office, the Office of Open Government, we also look at meetings and meetings records along with FOIA. So this case somewhat intersects those two areas because it deals with a commission, and this commission asserted its status as reason that it was not subject to the Federal Freedom of Information Act. So this was not a decision creating an AI-specific FOIA rule exemption. The court asked the threshold institutional question, did Congress create an entity that fits FOIA's definition of an agency? Once the answer was yes, ordinary FOIA obligation followed. So FOIA coverage turned on what Congress created, not the fact that the commission was studying artificial intelligence. So Congress gave the AI Commission governmental form and function. It created more than a study group. It located this commission in the executive branch, called it an independent establishment, appointed federal employees for life of the commission, and required reports to the president and to Congress. Most members were congressional appointees, while the secretaries of defense and commerce appointed 3. Congress funded the commission through a $10 million defense appropriation. So this was a temporary 15-member body charged with reviewing AI advances and national security needs. Its report would carry findings and recommendations for actions by Congress and the executive branch. So EPIC, the plaintiff sought access before the commission's recommendations had hardened. Timing was important here. EPIC was seeking the policymaking record while the commission was still developing recommendations, not merely after the work was complete. So this implicates a FOIA exemption for a deliberative process. There was a preliminary injunction that EPIC filed, but it did not show irreparable harm. And then after that, EPIC asked the court for expedited briefing on whether this agency was subject to FOIA at all. So we see the first request was to the Department of Defense for the commission records, required report, meeting notice, and access under FOIA and the Federal Advisory Committee Act. And that's the federal law that requires these meetings to be open. Request to the NSCAI, that was on September 11, 2019, records plus contemporaneous access to upcoming commission and subcomponent meetings. And then on September 17, 2019, the lawsuit was filed. EPIC sued NSCAI and its chair and the DOD after records and expedited relief were not provided. So I'm going to frame this opinion narrowly. EPIC's FOIA complaint alleged that NSCAI failed to comply with response deadlines and expedited processing duties and improperly withheld agency records. The government's partial motion asked the court to dismiss those claims on the theory that it was not an agency. The court rejected that threshold argument. The remaining processing and withholding issues were not resolved on the merits of this opinion. And the FOIA complaint raised 4 questions, and agency status came first. Does FOIA's definition of an agency reach the commission? Did EPIC qualify for accelerated treatment under FOIA? Did NSCAI comply with FOIA's statutory response requirement? And did NSCAI improperly withhold responsive agency records? So the agency status turned on 2 texts, the FOIA law, federal law, which defines agency as an executive department, military department, government corporation, government-controlled operation, or other establishment in the executive branch, and the entity's organic statute. It established NSCAI in the executive branch and said it shall be considered an independent establishment of the federal government under 5 U.S.C. Section 104. Congress could have hardly been clearer. The court found this statutory test unambiguous. It also drew negative inference support from the same. Congress expressly exempted separately the Cyberspace Solarium Commission from FOIA, but it gave this entity no comparable exemption. The government's narrowing theories did not overcome the enacted text. So the government's position was that this board was advisory, did not exercise substantial independent authority and presented separation of powers concerns because most members were congressional appointees. The court rejected each route as a basis for ignoring the unambiguous test. The court denied dismissal, but it did not order blanket disclosure of records. So yes, it said it was an agency. Yes, that status as an agency was verified. The deadline count, it was not dismissed. The expedition count was not dismissed, and the withholding of the records are pending. So the opinion did not decide exemption, segregability, or whether every requested record must be released. The ruling converted a novel AI commission into an operating FOIA program. So the practical consequence of this case was not merely a doctrinal label. The court was clearly saying here that congressional intent matters. The subject matter is not significant. So what has happened thus far in January 2020, NC and I keep saying NC, I apologize. NSCAI produced 105 pages in January 2020, including internal email concerning the language in its interim report. There's a rolling disclosure that happened between 2020 and 2021. 14 commission productions followed through February 2021, alongside DoD productions and agency referrals. Case closure, and that's in July 2021. After public meetings and thousands of pages of records, the parties resolved an attorney's fee claim in July 2021. So functional analysis pointed to the same result: text first, function as confirmation. The court treated the statutory language as dispositive, then explained that the government would lose on its preferred functional approach. The commission did the type of government evaluative work precedent had treated as agency activity. I think that's the duplicate. And so the disclosed records show why AI policy process records matter. So drafts and emails show how to report language, judgments, and public positions involved. External briefings, materials address social scoring, surveillance, AI threats, and workplace screening authorities. Working group files, agendas, conclusions, status reports, and preliminary recommendations preserve the decision trails. Governance records, best practices briefings, delegations, organizational files, and ethics disclosures reveal an accountability structure. The value of the productions was process visibility. So that is important to know in these FOIA challenges that are coming forth, that what the public and public interest institutions want to make sure is that they understand the government's process when it comes to artificial intelligence. So the lessons here for DC: this case is persuasive, not controlling. FOIA's definition governed a federal commission. DC FOIA has its own text covers, exemptions, and procedures and case law. The operational questions about authority, custody, retrieval, and public functions, though, are highly relevant to what we do in DC. So what carries over to us? Make sure that you, as a FOIA officer, you read your enabling legislation to make sure you understand your position as a entity subject to FOIA. What is the public body that's responsible? Test, custody, control, and retrievability. What DC FOIA adds: reasonable efforts to search electronic systems. So our framework that we have put forward with that, mostly through emails, is that to produce voluminous records on a rolling basis. So if an AI matter comes to you, you would use that principle again, because I'm sure it would be a task to have to review all of those records. Access to in requested electronic formats when available. That's an issue that's going to come up in the district when someone is looking for AI related record, what format are you going to provide it? That's still a question we're going to have to answer in the district. Since the council has received an AI request, maybe they'll be able to advise us on what that looks like on the back end. Contractor records for public functions remain reachable. So one of the issues that may arise is, again, do contractors of the district use AI, and how are we to reveal those records? The second Epic versus Department of Justice case is also an important case. It's an older one, and it's one of the first cases in this area about predictive policing. This is a case that we should pay attention to in the district. This was a federal FOIA action brought by the Electronic Privacy Information Center, again, EPIC, seeking records regarding the Departments of Justice use of algorithmic decision-making in the criminal justice system. The lawsuit arose after the Department of Justice allegedly failed to make a timely determination and failed to produce responsive records following EPIC's FOIA request. Specifically, EPIC sought records concerning predictive policing, evidence-based risk assessment tools, sentencing algorithms, recidivism prediction models, and DOJ policy regarding artificial intelligence and algorithmic criminal justice technologies. So the facts of the case are as follows. Beginning around 2015 to 2016, federal and state governments increasingly relied upon statistical algorithms to assist criminal justice decision-making. Examples of that decision-making included pretrial release recommendations, sentencing recommendation, recidivism predictions, predictive policing, and resource allocation. Civil Liberties Organization questions whether these systems contain racial bias, lacked transparency, relied upon proprietary software, violated due process, and were scientifically reliable. To understand the Department of Justice's role in developing these systems, EPIC submitted a FOIA request seeking agency records. The DOJ did not provide the records within FOIA's statutory lawsuit, during the time frame, the statutory deadlines. Therefore, EPIC filed the lawsuit. Now, I'll just go over the procedural history, which in my notes, EPIC submitted a FOIA request to DOJ. DOJ acknowledged the receipt, produced only limited records over time. EPIC filed the suit in U.S. District Court for the District of Columbia. During the litigation, DOJ did release responsive pages. The dispute ultimately proceeded to the D.C. Circuit concerning one particularly important withheld report, and DOJ eventually agreed to release the report. So the issue the case considered is whether DOJ improperly withheld agency records concerning predictive policing and criminal justice algorithms in violation of FOIA. The court found DOJ improperly withheld records, and the litigation resulted in the disclosure of hundreds of pages of DOJ records, internal policy documents, research regarding predictive policing, algorithmic criminal justice materials, and the report. The predictive analytics and law enforcement, a report by the Department of Justice. This report had previously not been made public. Why this case matters? Although the case didn't establish groundbreaking new interpretation of FOIA exemptions, it's significant because it demonstrated that FOIA can be used to obtain records concerning government use of artificial intelligence and algorithmic decision-making. It is one of the earliest cases to consider the government use of AI and predictive analysis. The litigation established that AI-related government records are subject to FOIA like any other agency records. The public interest in algorithmic transparency can justify aggressive pursuit of agency records. Litigation may be necessary where agencies possess emerging technology records not routinely disclosed, and FOIA can uncover previously unknown government reports concerning AI policy. So the AI litigation themes: was the AI output a record? Was the record retained? Did officials rely on the record? Is it deliberative? Can factual material be segregated? Was the search adequate? Does contractor possession defeat control of the record? Security versus transparency versus trade secrets. So these emerging cases have not produced a clear nationwide answer to any of these questions or several of these questions. But are AI prompts agency records? I would say they probably are. When they're created, used, received, or maintained in conducting agency business and maintained within agency control. But litigation will likely turn on the traditional record and control test, not on whether the content was typed into an AI platform. So it is the same government business in a different electronic form. So about model outputs, are those like agency records? Likely so when officials save, circulate, and rely upon or incorporate AI model outputs in their decision making. But that's something that we'll have to look to the courts to see. I think that the largest area that we're going to look on to the courts to decide is federal exemption 5 or district exemption on deliberative process. Agencies in the district, we're likely to argue that our use of AI prompts, draft, and outputs or recommendations are just part of our deliberative process and not the final records. The public is probably going to claim a right to understand how we were influenced by AI. Vendors of the district, like Microsoft being one, will probably claim trade secret, security, or investigatory privileges. A lot of these tools that we use are proprietary, so the provider of those AI tools may want to keep the government from revealing their proprietary information. So practical guidance for U.S. FOIA officers on this issue. The district has developed an AI governance framework, but within your agencies, you should look to see if you have developed procedures for retaining AI, for discussing it, and things of that nature. Prompt retention, think about that. Think about record presentation. Consider creating an inventory of the AI that you're using. Documents that are produced using AI, figure out a way to flag those. Procurement records, also human review is something that you consider. If you have any bias testing that you've used in the use of AI, that's something to make sure that you flag for an issue that may come up in a FOIA request. What are the search protocols that you will use as a FOIA officer or as other government officials? Look at your vendor contracts. That's something OCP will probably eventually address. And employee guidance, make sure you are familiar with the guidance that the Office of Chief Technology Officer provides regarding artificial intelligence use in the district, and make sure that you take your security training. I know Kevin, our IT lead, always makes sure our agency stays up to date with security training and AI training. So when that's available, make sure that your agency avails itself of that opportunity. So unresolved questions, again, are prompts, agency records, are chats discoverable? Must prompt histories be preserved? Can the deliberative process exemption cover AI recommendations? Are hallucinations responsive records? And those AI hallucinations are when you put something in a LLM model and it comes back with something that's absolutely ridiculous. Is that a responsive record? When is an AI output adopted as policy? What part of the process do we need to identify as a government that AI has been involved in? And must agencies explain algorithmic reasoning? So I will close with this. The key takeaways: advances in technology do not change FOIA principles. It changes where the records exist. It changes how we search. It changes how we preserve, and it affects exemption analysis. And it changes how courts define records, but it does not change our obligation to be transparent. So that's the end of my presentation. Again, we are the Office of Open Government. Contact information is here. There will be a recording available for your review, and also this slide will be available. I will put links to information about the cases in the chat. All right, so we come to the portion where if you have any questions, please ask them. I know we have one in the chat, which I will get to. Thank you, Attorney Skirbo, for that. Is there guidance on disclosure of requested records data stored in a large database aggregated with unrelated data and PII? Is the agency expected to run a report to extract the requested data? How to resolve the tension between disclosure and not creating a new record? What if the records databases are shared by multiple agencies? All right, so I'll start with the first one. So the Office of the Chief Technology Officer would provide the expert advice on this. But my advice is it's going to be specific on what the request has asked for. So you should be able to extract based on search terms or what the party has asked for. You should not have to produce the entire database. Where there is PII, whatever you release, you're going to have to redact, or if it's such that redaction would not preserve the PII in that record, you can withhold it as a whole, but you are not required to release the entire database. For specific information on that, I would have you reach out to Octo. But is the agency expected to run a report to extract the requested data? I think that would be, yes, that would be part of it. You're not required to create a new record, but you are required to conduct a search. So that would assist you with your search. But the report is not necessarily a record because you were creating that as part of your process for searching. So I don't think that is required, but you might need to do that for a reasonable search. So I guess that gets to the second question. And let's see, what if records databases are shared by multiple agencies? You would need to consult with those agencies on that request. Do my colleagues of OG have anything else to add on those questions?
I agree that it's a highly fact-specific analysis. Depending on the nature of the database and how the data that's being requested relates or lives next to or with the other data that has not been requested, it becomes more of a technical question than a FOIA question. And if there are, records and databases shared by multiple agencies, we always advise following the federal DOJ guidance on consultation and conference with those agencies.
Thank you for that, Anthony. Are there any other questions or any comments? I don't see any in the chat. I would just like to say thank you for coming to this training today and for your participation in the district government as a FOIA officer or other professional. If you have any questions about anything that was in this presentation or about FOIA in general, please reach out to us at the Office of Open Government. Reach out to me. My email is niquelle.allen@dc.gov. My phone number list is there on the presentation where we are here to help you. So you're not in this alone. So I hope that you all have a wonderful weekend. Happy Friday. And we hope to see you soon. We have another training next week that will be conducted by the Office of the Attorney General, Civil Litigation Division. The OAG attorneys will be speaking to you about FOIA litigation, how to prepare for litigation. That is a privileged conversation, so it will not be recorded, but we encourage you to please attend. And also your legal staffs, if you would like to invite your general counsel's office, we appreciate that. I think it's something they could benefit from. So, all right. Well, with that, I will adjourn and you're very welcome. I hope to see you all next week and enjoy the weekend. Bye-bye.